Hello, everyone. I'm Jeff Hampton with the Hampton Law Firm. Today we're going to talk about assault public servant. Maybe you're facing an assault public servant charge and you have no idea how that possibly came about. And maybe you've got a loved one who you can't imagine how they could have been charged with this offense. And I want to sit down with you today and spend a few moments breaking down the law. What does Texas law have to say about being charged with an assault public servant? And what can be done to defend those charges to protect your clean record and make sure you maintain your freedom? Now, if you wait around till the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, so let's talk about assault public servant. Now, assault public servant is a felony charge, but it's not really all that different from the basic charge of simple assault. In fact, it's basically the exact same elements under the penal code, except the added element of it being a public servant, whether it's a police officer, EMT, firefighter, and we'll talk about that element here in just a minute. In fact, what I want to do is read to you for just a second what the law says. You're going to find this Texas Penal Code section 2201 under the assault section. That's section 2201. And then there's a subsection B. Okay. So here's what it says. Basically, normally a person commits an offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. Okay. Now you add to that element subsection B. An offense under this section is a Class A misdemeanor, except that the offense is a felony of the third degree if the offense is committed against a person the actor knows is a public servant while the public servant is lawfully discharging an official duty, or in retaliation or on account of an exercise of official power or performance of an official duty as a public servant. Now, if you go further through the Texas Penal Code, it kind of drills down specifically circumstances where the accused would need to have known, the person being charged with this offense would need to have known that this individual was a public servant. But it also lists specific people. It's not just police officers. It also lists, like I mentioned a second ago, emergency medical technicians, paramedics, law enforcement, police, even security guards, firefighters, and emergency room personnel. Okay, so all of that is articulated. Now, here's a very weird part. I've seen the district attorney's office try to tie this in, but there is a portion of it that's a broad generalization at the end of the section of how Texas defines emergency services personnel. This is a little bit of concerning. I want to read it to you. The law states that emergency service personnel include people working in all the positions I just mentioned to you a moment ago, and other individuals who in the course and scope of employment or as a volunteer provide services for the benefit of the general public during emergency situations. Now, that's very broad. It's also very general, very generic, which sometimes leaves it open for a prosecutor to try to overcharge someone, elevate their charge from a regular Class A misdemeanor assault up to a third-degree felony charge under that definition. So here's the real question. Say, the people ask me this all the time. Well, what if I did get into some type of altercation and the police were being unfair or they were being rough with me, but there was nothing wrong with the officer? I didn't see any visible injuries on him. Can I still be charged with assault public servant when there are no visible injuries? I see it all the time. Absolutely, you can. If the officer claims this person contacted me, I think they meant to do it intentionally, and it hurt. Officer says it hurt, even though there's no visible any injuries to observe. That's enough to establish probable cause for an arrest. It may not be enough to establish proof beyond a reasonable doubt, but obviously at that point it comes down to the police officer's word versus the accused. And so that comes up all the time. Now, I want to give you some examples of how someone can be charged with assault public servant, okay? So many times I've represented some people. These are some examples of people that I've helped represent where they had no control over the situation, yet they find themselves staring down a third-degree felony for issues that had nothing to do with them. Let me give you an example. Hypothetically, clients involved in a car accident sustains a head injury. Of course, the emergency paramedics show up, that client is confused, they're frightened, they don't know what happens. Someone comes and tries to extract them from the vehicle. The client gets very upset and begins to thrash around, and in the process inadvertently hits the emergency medical personnel, and it causes them to have a bloody nose, or it causes an injury, and that client was subsequently arrested. Now, I'm going to talk about how we can defend that here in just a minute, but that's one example. Another example is you're involved in an altercation. Let's say it's in a backyard barbecue, or maybe you're at a local restaurant or something like that. Police show up to break up the altercation, and in the process of an officer coming from behind that individual and grabbing them, that the client turns around and tries to defend themselves and elbows this police officer in the face. And now all of a sudden, what do you think happened? They're being thrown down on the ground, they're getting handcuffed, and they're being charged with a third-degree felony. Finally, what about an altercation during arrest? And I've seen this more frequently in the last few years, where people understand that they're being arrested with the police officers grabbing a hold of them, and during the arrest, the individual being arrested is being hurt or injured during this process, and they respond back almost involuntarily, and it causes whatever minor injury to the police officer, yet it's the client, it's the accused who ends up being charged with this third-degree felony. So as you can see, an assault public servant is not always maybe the way it's made out to be. Many times there can be very inadvertent issues that come up, inadvertent actions by the client where they were not at fault for what they're being charged with. Now, let's talk for a second about what the punishment is. I said that it was a third-degree felony. Well, a third-degree felony in Texas is punishable from a minimum of 2 all the way up to 10 years in prison and up to a $10,000 fine. So it's extremely serious charge, and it's elevated simply because emergency personnel or a law enforcement officer was involved. Now, the question comes back to this again. What if there was no physical contact? What if I didn't even realize I did anything to him? Can I still be charged? Once again, it comes down to that police officer's word. So people start asking me all the time. They come into my office, and I'll give you a personal example here in a second of someone that I represented. They say, can I still be charged with something like this? I mean, I didn't do anything wrong. I didn't mean to do it. It was not intentional. Can I still be charged, or can they prove that case beyond a reasonable doubt? Well, let's talk about a defense. One of the primary defenses, one of the number one defenses to assault of a public servant is that the alleged accuser or the alleged accused must have known that the alleged victim was a public servant at the time of the incident. I represented a client who was at a bar, very loud, and one of the police officers who was going to come up and ask him to leave came up from behind him, grabbed his shoulder very aggressively to turn him around. My client had no idea this was a police officer. He certainly wasn't wearing a badge, and he didn't know who this guy was. He thought this was somebody, a bar patron who was coming in to be aggressive towards him, turned around and ended up hitting the officer. That case had to subsequently be thrown out because there was no proof of being able to show that at the time of this incident that our client actually knew that this was a police officer or could hear anything that he was saying. So that's one of the areas for a defense. And then also, if you acted in self-defense, we had a client that was was actually visiting a local bar. It was actually a concert not that long ago, and was there just minding their own business. The bar decided they did not want them there anymore because of an exchange of words. And as they made their way out the door, words were exchanged again between our client and the police officer. The police officer grabs this female client, throws her across the room, and then gets on top of her. She kicks back, trying to keep her head clear on the concrete. She gets charged with assault public servant. Well, in that situation, that case was able to be presented to a grand jury to show that there was no intent. In fact, more importantly, the client was acting in self-defense. The client was being attacked by the police officer, and the client was attempting to defend herself from those actions. So it's very important that is still, self-defense is still an option if a police officer is acting outside the scope of their authority or if they're being aggressive themselves. Okay, I've gone through a lot of different options here. Maybe you or a loved one maybe you're facing right now the prospect of an assault public servant charge, and you would like to have a free consultation. I encourage you to give us a call at the Hampton Law Firm at 817-877-5200. We would be happy to go over all of the questions that you have, see if we can do anything to assist you. And I appreciate you waiting around till the end of this video. If you'll click the link below, I'll send you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Thanks again for joining us today, and I look forward to seeing you on our next video series.